There's nothing some realtors love more than to adding personal property onto the contract. Washers, dryers, hot tubs, pool tables, you name it. We've seen everything imaginable on the purchase contract. So in today's video, we're going to look at what to add, what not to add, and how to handle it if it is added on one of your contracts. So personal property, or chattel, is sometimes added onto a real estate contract, and it may be an innocent thing, like we want the curtains, or maybe we want the washer and dryer, we want the stove or the refrigerator. Other times it's a little bit more detailed, like the seller doesn't want to have to move the pool table or the hot tub or whatever it is. So how do you handle that? Fannie Mae specifically says that they will not allow personal property in the contract. In fact, I'll read here. It says seller concessions that take the form of non-realty items are not permitted. They include cash, furniture, automobiles, decorator allowances, moving costs, and other giveaways. FHA goes on to say that we will not allow any personal property. If you do put personal property on there, FHA says we're going to reduce the purchase price by the dollar value of that personal property. So now, first off, the question is, what is personal property? In the easiest terms, if it's not affixed to the property, it's personal property. But there's a little bit of a but in there. If it's customary for the area, then it's not considered personal property either. They allow it, such as washers, dryers, refrigerators, stoves, stuff like that. Pretty customary, even though they're not permanently affixed. What about pool tables? Well, that's obviously a personal property. The best way to handle the personal property is remove it from the contract completely. You can do a quick strike through, just a one-line strike through on the line, or you can do it a complete amend extend. The cleanest way to get you through underwriting is don't have any personal property on the contract whatsoever. A couple more quick notes. Let's say you have a television that's sitting on an entertainment center. That is personal property. That same television mounted to the wall. We're seeing more and more that there's no clear definition on this, and most underwriters are saying if it's mounted to the wall, it's permanently affixed, and that's okay. Kind of interesting, right? The other thing is, let's say take something like, say, a hot tub. Now, a hot tub is sitting outside on your back patio, and it plugs into the wall. When that's plugged into the wall, that's personal property. If it's hardwired in, the plumbing or the electricity is hardwired into the house, that's actually that's part of the real estate. So this is an effort. It's to preserve real estate values. They don't want these inducements to buy in the form of personal property on the contract. So the cleanest, easiest way to do it, don't put personal property on your contracts. If you do, don't be shocked when the underwriter asks you to remove them. If you get a contract on a listing you have and it has personal property in there and you accept it, perfectly fine. There's no law that says you can't do it. But the loan, when they get the loan, don't be surprised when they come back and say you need to have that removed. Just prepare your clients to have that amend extend, and maybe even already have it ready just in case you need it. Hope that helps you guys out. Give us a call with any personal property questions. Happy to help you out and help you have a more successful transaction and deliver a better experience to your client. We'll see you next week.